Good afternoon, and thank you so much for joining us on this webinar regarding landlord tenant law. And we're going to invite our guest, attorney Conrad Grant, to basically go over some really important points for you on landlord tenant law. And I know he had some updates too, and we'll let you know how you can access YouTube um, presentations on some updates that me and him were talking about yesterday, basically on service animals. And so he'll talk very briefly in this webinar about that, but then also we'll give you some information on how you can access more information through Conrad and his website in order to follow up on that information. So I do want to invite everybody to go ahead and ask questions during the webinar. We will answer questions as we go. Everybody does remain muted on the webinar, so the way to ask your questions is go ahead and type them into the question box, and I will make sure that we get those questions answered for you. This webinar is going to be recorded, so if you want the opportunity to either share the link or go back and review it, you will be able to. It'll be emailed to you as soon as the recording is available, and then also you can access it on Advanta's YouTube channel just by searching on YouTube Advanta IRA. All of our webinars can be accessed through the YouTube channel, anything that we've archived. And actually, this is not the first webinar that we're doing with Conrad, so there you can check out the previous ones there, but this is, of course, going to have the most up-to-date information for you. My name is Larissa Green. I'm with Advanta IRA. So for those of you that don't know me, I'm going to go over just a quick couple of minutes on self-directed retirement accounts and how you can utilize those actually to acquire rental property through your retirement account. So again, I don't want to take up too much time. I want to make sure that we give Conrad plenty of time to present the material that he put together for you. I already did have a question pop up, and I love these questions. Somebody asks, hey, I'm a CPA. Is this webinar eligible for continuing education credit? And the answer is, I'm going to actually leave that up to you and the agency that you have to report your hours to, but I would be happy to provide you with a certificate of completion. Just make sure you go ahead and contact me at the contact information on that screen. I'll give you the certificate, and then you have to go ahead and do your due diligence and see if it's going to qualify. So let's continue on here. I'm going to give you some information on Advanta and basically what we do for individuals who want to invest in real estate and real estate related investments. And so brokerage firms, those are great places for you to go and invest in things like stocks, bonds, and mutual funds, but they don't allow you to hold tangible assets like real estate. And of course, there's other types of investments out there as well. But real estate is the number one investment we see. And so we definitely specialize in things like rental properties, rehabs, private mortgages, option contracts on real estate. And so Advanta is a self-directed IRA administrator or a third-party administrator for retirement accounts. There are a couple other accounts that we can hold, and we'll talk about that in just a minute. But we've been doing the record keeping for these accounts for the last a little over 17 years now. We have 2 offices, but we can work with anybody, anywhere, so that includes nationwide and even worldwide. We don't sell any investments at all, so investing your money is going to be completely up to you. When the money comes over to Advanta, it is going to sit in a cash position until you put it to work. And so that's very important. It's going to be completely up to you to do your own due diligence, find the investment, feel comfortable with that investment, and also kind of look at what the growth is for that account. When it's sitting in cash, it's going to sit in cash with us until you put your money to work. Something that we don't do at Advanta is give you advice on your investment. So we're not going to give you legal, tax, or investment advice at all. We're not going to do any due diligence. Sort of what we do here is we're going to educate you on the rules of the things that you can do within a self-directed IRA and what the rules are. So the IRS says you can do this, but there are some rules that you have to follow when you're making those investments. And so we're going to help you understand those rules, but outside of that, it's going to be up to you, again, to do the due diligence, feel comfortable with the investment. If you have questions beyond what I can really answer for you, you can ask it anyway, and I might be able to refer you to a professional like Conrad who can really help you with those questions. So some really important points that I like to make about a self-directed retirement account are listed here for you on the screen. And I think that the reason I like to really emphasize these points, sometimes people forget. They come to me and they say, well, what types of investments do you have that you can put me into? And again, it's going to be up to you to find the investment. So I'm going to start with the first one here. Any IRA or former employer plan qualifies for self-directing. For whatever reason, a lot of times people feel that it has to be a Roth IRA. I'm not really sure where that comes from, but you don't have to move your money into a Roth IRA, pay the taxes in order to self-direct. So if you have an account that ends in IRA, it can be self-directed. If it's a former employer plan, so a 401k, a 403b, a TSP, a pension plan, all of those, as long as you've severed ties with the employer, can be self-directed simply by rolling them into an IRA. You choose the investment, and then all expenses are paid by the IRA, and any income is received by the IRA, and all of that is related to the investment. So for example, if you buy rental property with your retirement account, then it's going to pay all of the expenses. So whether that's just simply property taxes and insurance, or if there's utilities in there or some repairs that are needed, all of that has to be paid by the retirement account. And then any income is going to be received by the retirement account. Remember, the purpose of this account is going to be to grow the retirement. And really, the idea behind a self-directed IRA is investing in what you know best. So using your expertise to grow the retirement account. Most people haven't heard of self-directed accounts simply because brokerage firms are unwilling to hold these tangible assets. They consider them hard to value. They don't want to have a fiduciary responsibility over something like an option contract or a mortgage. And so what we do really is we're not their competitor. We just simply fill the gap in the industry for this service. So we allow you to make these investments, but on the reverse of that, we actually don't hold anything publicly traded at all. So we can help you with things like private stock and gold and silver coins. But if you want to trade in the market, you would want to find a brokerage firm that can help you with that. And just a little known fact here is that less than 4% of all, and it says IRAs on the slide, but actually it's all retirement accounts, are self-directed. So that includes anything like a pension plan or anything like a 403b or 457 plan. All of those plans are typically invested in things like mutual funds and anything market-based, and so less than 4% of all accounts are truly self-directed. I already listed out the types of accounts that can be self-directed, but here they are on a slide for you. So gives you an idea of the types of accounts we have here. I have listed up here outside of retirement accounts, education savings accounts are also known as Coverdell accounts and health savings accounts. So the rules for self-directing those accounts are going to be exactly the same. And so really, we can hold those types of accounts for you. We can help you understand the rules. But for a health savings account, for example, it would be up to you whether or not you would be eligible. So you would just check with your plan provider, and they would let you know whether or not you're eligible to make contributions to a health savings account. And then an education savings account is a great account to make a contribution to. Distributions for education are a little more liberal than something like a 529 plan, but unfortunately the contribution limit on those is $2,000 a year, and it hasn't gone up in years and years, so we just don't see as many education savings accounts as maybe we would like to. And I'd just like to give an idea of the types of investments we see here at Advanta on a regular basis, because a lot of people just automatically go to, okay, rental property, and it has to be something like a single family home, and it has to earn income. But the truth is that your investment strategy is your own. And so if you're investing maybe into something that's syndicated, like commercial property, where you're a limited partner in that investment, that is absolutely something you can do with your IRA. The IRS doesn't have any requirement on you holding a property for a certain amount of time. So if you want to rehab a property and flip it, you can certainly do that. It can be residential of any kind, including condos and duplexes, multifamily properties. You can do things like short-term vacation rentals, as well as, of course, buy and hold long-term. All of those will work. And then, of course, if you're not interested in tenants, toilets, and termites in your IRA, I know a lot of investors who maybe do this personally, but they say, you know what, when it comes to my IRA, I'd rather not have to worry about tenants. And so we see a lot of things like private mortgages in IRA, so lending money on somebody else's rental property. You can also have things like tax liens and option contracts, assignments. There's a lot of joint venturing going on. I'm sure right behind me where I'm sitting in our office, our operations team is probably working on joint ventures today, because that's a very common strategy that we see used with self-directed retirement accounts. And then up here, I also have the other alternative assets. And a lot of times we look at this list and we're kind of surprised to see what might be listed up here. But keeping in mind, again, a self-directed account really enables you to use your knowledge to grow your retirement account. And so if you work with cattle and racehorses on a regular basis, that's how you earn a living, then you may want to invest your retirement account there, because that is what you understand. And so we've seen clients do that. We've also had clients invest in things like movie projects. We've seen large equipment leasing, so farm equipment like tractors, but also things like ATM machines and large format printers. For foreign currency exchange or Forex accounts, option trading, private stock, commodities, oil and gas, these are all things you can do with a self-directed account. And if you didn't see an investment strategy up there that you're considering, it doesn't mean that it can't be done in a self-directed account. It just means basically that, you know, I either haven't encountered it before, or we don't see a whole lot of that type of investment. So you're certainly welcome to email me or give me a call, and we can discuss what it is you're considering for your IRA and whether or not it will work. And I'm just going to really quickly go through this case study here, but I want to give you an idea of what holding rental property in an IRA looks like. So in my case study here, Susan has an old 401k with $120,000 in it, and she's going to roll it over to Advanta in order to purchase real estate. And so the idea behind this is giving you the information that you do need to actually hold an account with Advanta. So you're going to go through the process of opening an account, and then from there, you're going to find the investment. So Susan is going to find a property and negotiate the price. And I always joke, you don't want me negotiating the price for you, because you'll pay more than list price if it's up to me. So you're going to go out there and negotiate that price, maybe have a professional do that for you. And once you come to your agreement on terms, you would come to us and say, okay, this is what I'm doing. I need your help to do it. And we're going to make sure that you get everything from the contract to closing documents in the name of the IRA. And then we're going to fund that investment. So in this example, Susan finds a property for $85,000. She determines it's going to need $15,000 worth of repairs, and then once it's done, she's going to have $1,000 a month go back to her IRA and rent. So again, Susan's going to open and fund her IRA account. We're going to help her with that process. She found the investment, made the offer, and came to an agreement with the seller. Then we're going to help her make sure that everything is titled properly. We do have Susan read and approve everything, so we need her signature on everything, but Advanta IRA is actually the legal signer on behalf of her retirement account. So once she approves all of the documents, we will actually sign on her behalf. And then from there, we'll execute the closing documents and fund the closing. And so money comes out of Susan's IRA account and goes to the closing agent, or whoever that might be, whether it's a title company or a closing attorney. And then from there, any expenses for repairs, maintenance, taxes, insurance, all of that is going to be paid by her IRA. And so Susan is going to come to us, reach out to her account manager with Advanta IRA, request a check for whatever services or whatever expense needs to be paid, and we will go ahead and issue that check on her behalf. So that's very important. You see here in red that the IRA holder cannot write checks for expenses or deposit checks for rental income into their personal account. That's very important, that the flow of funds for IRAs are always in and out of the IRA account. And I know some of you on this call are probably thinking, well, what about checkbook control and using an LLC? I'm really not going to go into that today, but I have a whole seminar based around that as well, and I'd be happy to share a recorded webinar on that with you. But for the purposes of this case study, Susan owns the IRA or the property in her IRA directly. And so therefore she's going to reach out to her account manager Advanta to pay any expenses. And then all of the income is going to come back to Advanta. So when Susan rents the property out, she's going to have her tenant make checks payable to Advanta IRA for benefit of Susan Smith, IRA number 1234. And when we receive those checks, we're going to go ahead and deposit them on behalf of Susan's IRA directly to the account. And she can follow along with deposits made and money going out of her account through email notifications and, of course, our online platform. And our online platform also allows you to pay expenses directly on the platform. So you can submit a request. The check will go out the next day. I had a question pop up: who deals with renter issues, and the answer is Susan. She can't manage the property in the true sense, and so if you're really looking to be hands-on there, then sort of the answer to that would probably get somebody who's going to do property maintenance for you, but she can certainly oversee anything that the tenant needs, meaning when the tenant calls and says, hey, there's a plumbing issue, Susan can hire a vendor to go out there and repair the issue. Then she would let us know who we need to pay for that repair. If the tenant, is having issues of really any kind, they're going to always reach out to the IRA account holder. But any repairs that actually need to be done, and again, this is in other webinars and educational seminars that we have, but the rules say that she can't provide any sweat equity. So meaning she can hire a vendor and really negotiate, anything that needs to be done for the property, but she can't do it herself, and she can't pay for those expenses herself. So she always needs to be at an arm's length transaction for these investments. And I do see another question. Can you email out the slides? And I'd be happy to do that. Just make sure, again, that you email me or give me a call, and I'll make sure that you get the slides from this presentation. And so with that, I'm going to actually turn it over to Conrad, and I'd like to introduce Conrad. He is an attorney. He has done these webinars for us before, and he really explains everything so very well. So thank you so much, Conrad, for joining us.
You're welcome. Thank you. Good afternoon, everyone, or good morning, depending on where you are. My name is Conrad Grant. I'm an attorney with the law firm of Kelly & Grant. We're headquartered in Boca Raton, Florida. So today I'll be discussing Florida landlord tenant law. If you are not based in Florida, you will still glean valuable information because your state might not do things the same way, but you will have an idea of how rental properties in general are going to be handled when it comes to the legal issues with tenants. So this is typically a much longer class. It's going to be abbreviated. So if you see me skip a few things, you're not missing out. I'm just shortening my explanation. So today we're going to talk about non-tenancy issues, what to do during the tenancy, during an eviction, and after a tenant vacates the property. And let's get started. So we have a process called unlawful detainer here in Florida. It exists in other states, but in fact, some evictions are called unlawful detainers in other states. But here in Florida, we use unlawful detainers for squatters and unwanted guests. So, for example, you buy a property, you get a good deal on it, and you find out that there's someone living in it, someone is squatting in the property, or you had it locked up and someone is squatting in the property. It can also be used for unwanted guests. This could be your brother or cousin who was supposed to stay with you for a month, and 3 months later or a year later, he or she is still in the property. So how do you remove that person? Let's look at it from the point of view of dealing with a squatter. First, you must have a legal right to possession of the property. So if you closed on the property and you now own the property, then you have a legal right to possession. You then need to ask them to leave. So just saying I knocked on the door and told them to leave isn't enough. You need to have it in writing. So you should just give them a note. We typically do it for our clients. We just say, hey, we're the new owners of the property. you need to vacate the property, and we give them a date. It could be a week. It doesn't matter. There's no statutory limits. You just need to ask them to leave and be able to prove it. They then refuse to vacate the property. So all those three elements must be satisfied. And remember, this can never be a person who paid rent, because then that would be landlord tenant. What I'm talking about here is a person who is not a tenant. It is a squatter. Okay? So then it's subject. Unlawful detainers are great because they're subject to summary procedure, which is a shortened time frame for lawsuits in Florida. If you think about lawsuits in general, they can take a long time. You have 20 days, 20 to 30 days for the other person to respond, and then they can do discovery, and they can buy a lot of time. With evictions and unlawful detainers, the time frame is much shorter. So that's it for squatters. You bought a property, you want to get rid of someone in the property, unlawful detainer is the way to go.
Okay,
Here
Conrad,
is,
before you go
yes,
on right from there, I did have a question
yes,
pop up about that. What if they
sure.
say they're going to leave, but they never go anywhere?
That's where you'll need the lawsuit. You always, all roads, and when it comes to possession of property, leads through the courts. So it's best for you to give them that notice. And yeah, they can promise you they're going to leave, but when they don't leave, that's when you already gave the notice, and then we need to file an eviction in county court. So that's where this is all going to end up in county court if the person does not leave. Okay? And I'll explain some of the court process to you later, but that's where. So good question. But county court is where you're going to go next. All right. You also have motions for writs of possession. And this is auction property. This is your property that you buy at auction, usually through the county auction, that is. So you buy this property, and now you find out that someone's living in the property. Usually that's going to be a squatter or the former owner. And all we need to do, just to explain what this motion for writ of possession means, is we reopen the foreclosure case and we ask the judge to issue a writ of possession. That's really it. So when a foreclosure is entered, the court order says that the court shall reserve jurisdiction to enter orders, additional orders, and writs of possession. So we're asking the judge to reopen the case and issue a writ of possession. A writ of possession is where the sheriff goes to the property and posts a notice, and then they come back later and remove whoever is in that property. And that's usually the end stage of all types of evictions, whether it's the squatter that I just mentioned to you before or evictions that we're going to discuss. It all ends with a motion for writ of possession where the sheriff shows up and removes the person from the property. So to get this motion for writ of possession, you need to have the certificate of title issued by the clerk already. That shows that you're the true owner. You then need to serve a statutory notice to vacate. FS 80, that's Florida Statute 83.561. Then we can demand proof of tenancy. If someone's living there and that person is a tenant, then they need to produce that information to us. And then we file the motion for writ. We'll have a hearing. We pay for the writ of possession, and the sheriff will then come out to the property and remove the person. It takes a few weeks, but that's the process. Now, this section, every state has something relatively similar. Not every state, most states, because the Protecting Tenants at Foreclosure Act was passed during the Obama era when there were a lot of foreclosures. So this is what Florida did. We adopted the Protecting Tenants at Foreclosure Act, and we included it in our statute. So a lot of states have some method that you need to use to remove tenants or occupants from property that was purchased through foreclosure. So you need to look into that just to see what the laws are. So let's move on to tenancies. Okay, so we're going to talk about 3-day notices. Let me go back. Oh, I think I skipped too far ahead. But the two notices that I just showed you, I just skipped through them very quickly. Those notices were, they were just examples of people writing very bad notices. So yeah, they are, and we get them all the time. And but this is what a true 3-day notice should look like. And this is plucked directly from the statute. This is available at our website. Anyone can download it for free, and it's just fill in the blanks, and it tells you what you need to do. And it has to be done exactly the way I have it. At least the information I have here must be included. Some property managers will add additional information to it, but as long as the additions do not take away or conflict with what I have here, it should be good. And you're going to put your dollar amount in, you're going to put the address of the property, the apartment, if any, the city, the state, the zip, the county, and then you're going to calculate the date that your notice is going to expire. And all these need to be done properly. This is what they call in law condition precedent. This has to be done first. And if it is not done correctly, then there's an argument to be made that you have no right to file a lawsuit. So you need to have a proper 3-day notice. And usually 3-day notices are used for non-payment of rent. So here's how you terminate a tenancy for non-payment of rent. You have to serve a 3-day notice. There's no way around it. Serve your 3-day notice. Make sure that if you use a P.O. box as a landlord's address, you add 5 additional days. That's just a rule. You need to remember it. It's best not to use a P.O. box. If the tenant attempts to pay you in full, you have to accept it. So no matter how you dislike that tenant, if you serve a 3-day notice for non-payment, that tenant has the right to pay or leave, because that's what the 3-day notice says. Don't give an early notice. Make sure you consult your lease. And if you bought this property as an investment property and you basically inherited this lease and you've dealt with leases in the past, don't assume that all leases are the same. Okay? Look at that lease. Look at whether they have a grace period. So my example here, if the lease gives until the 5th to pay, don't serve your notice until the 6th. Okay, because your notice will be defective. It will not be timely. Don't include late charges or utilities. You can only include rent on your 3-day notice. Do not include the day the notice was served. Do not include weekends or court holidays. And I have this all on my website, so if you need to revisit, if you can't remember all this, then these are the rules. If you're going to mail it, it's going to be 5 additional days. If the property is in Section 8, which is subsidized housing, then you have to notify the housing authority and send them a copy of your 3-day notice. So those are some rules that you need to follow to serve proper 3-day notices. Here's an example of how a 3-day notice would work here in Florida. So you have notice served on the 9th, and day 1, you never count the day that you serve the notice. So if you served a notice today, you're going to not count today. But back to my example, day 1 is so you see day 1, day 2, day 3, the notice would expire on Friday. You have to skip weekends and holidays, and look when we can file that complaint. We can file that complaint on the Monday. So that's typically how it worked. But let's back up a little bit. Let's say we serve that notice on the Monday. We could now file our complaint on the Friday because you would have 3 days. But I wanted to show you this example because I wanted to show you how important it is to skip the weekend. And if Monday was a holiday, you would need to skip that also. So when you're going to terminate a tenancy, prior to serving your 3-day notice, you need to consult your ledger first, okay? Consult your ledger to make sure that the money you're asking for is rent only. I can't tell you how many times I've received a 3-day notice with some amounts that I just can't do the math on. Rent is $1,000, but I'm seeing a 3-day notice for $1,852.60. That doesn't make sense to me unless there's a breakdown. And if we go to court with that, it's not going to make sense to the judge. So Florida law states that a landlord can only demand actual rent. There's a way around this. I'm actually working on a lease right now where I'm making some corrections for a client, and I'm deeming any additional charges as additional rent. So something that's not rent, like my client wanted me to add that if the tenant needs to rekey the mailbox, the cost will be $80, and the $80 will be deemed additional rent. So if the landlord wants to demand that $80, the landlord can add that to a 3-day notice because we made it into rent. But if those terms are not in your lease, then you can only ask for the actual rent, the monthly rent. Late fees, return checks, utilities, administrative fees, repairs, and so on can all be deemed as additional rent. So this is how you maximize your investment. Don't eat the NSF check fee or, late fees or utilities if it's a duplex, for example, and the tenant, you include the uh, the power on the bills. Don't eat that if the tenant doesn't pay it. Deem everything additional rent, power and water. So, practical considerations prior to serving a 3-day notice. Monthly rent is $1,600. Tenant is behind 2 months. Ledger shows the following entries, and you have it there. Total amount that's in the ledger is $3,520. So, what would you do here? So, the first thing I would need to do is look at the lease to find out whether the late fee is deemed additional rent. And if it says it's deemed additional rent, I'm going to say, okay, this is a good 3-day notice. $3,520 is correct. But if I scour that lease and I cannot find where late fees are deemed additional rent, I'm going to recommend that the landlord reserve. Because if your case is defective, your case could get dismissed. And if there's a lawyer on the other side, then you could owe that lawyer's attorney's fees. So just be careful. Remember those simple rules when serving 3-day notices. During the 3-day notice period, you have to accept rent. I already told you that. After the 3-day notice, but before filing the eviction, so there's this gap period, that weekend I showed you, right? If the tenant shows up with the money, you can accept the money. The tenant says, "Hey, I have the money. Please don't evict me." You can accept the money, or you can reject it because it's after the notice period. If it's a partial amount, you don't have to accept it, but you could accept it and you could serve a new 3-day notice on that tenant. So let me expand on this. So the tenant owes you $2,000. The 3-day notice expires on Friday. Expires on Friday. Tenant shows up on Saturday and says, "Hey, please don't evict me. I have your $2,000." You can accept that. Tenant shows up with $1,500, you could actually accept that and then immediately serve them a 3-day notice. Tenant shows up with $200, just reject it and continue with your eviction. That's not a good faith attempt to pay on the tenant's part. After filing your eviction, you should not accept any rent. If the tenant deposits money into your account, you need to return it via certified mail as soon as it clears. You can accept the money and dismiss the case if you want, but if you already spent money on legal fees, then you're losing money. So the best thing to do is enter into an agreement with the tenant. If you already filed a suit where you agree that, okay, I'm going to accept your money, you're going to pay back my legal fees, and I'm going to dismiss this case. And you can write an agreement that the judge will approve, and that is the best way to protect yourself. So there are a lot of investors or small landlords who make these mistakes all the time. Tenant will show up with $2,000 and they're like, "Oh wow, it's $2,000," but they already paid $435 or $500 for their lawsuit, and they cannot get that money back. So now they're out $500. So always make sure that you're made whole.
So a question popped up here, Conrad.
Yes.
Do you have to stipulate that late fees will be considered as additional rent in the original lease, or can you notify the tenant that fees are additional rent after the fact?
Good question. So if you're going to write an addendum to the lease, so let's say you have a 1-year lease and it's still active, and you want to add that, the tenant has to also sign it, and maybe they won't want to sign it. But if you're renewing the lease, then you could add it. But bottom line is this: if it's not already in the lease, you can't add it without the tenant's permission. The tenant would have to sign also. Okay? So,
Uh,
but if you're renewing, you can do it through an addendum. So
okay.
yeah, that's the best way to do it. If there's a renewal and you want to keep the same lease, we just do a quick renewal and we'll say, hey, we're agreeing to renew the lease for another year. And then you add any additional changes, and then you'll say all other terms remain in full effect, something like that.
Okay.
But yeah, it's too late if it's not already in your lease.
And I think this question popped
Mhm.
up, but I know you sort of already went over it, but maybe just to reiterate, can the landlord demand rent and late fees if those numbers are listed separately on the 3-day notice, or if it's not additional rent, can you not demand that?
If it's not additional rent, you cannot demand it on your 3-day notice. Just see if I'm answering your question correctly. You mean list it separately on the
Yes.
3-day notice?
Hmm.
If it's deemed additional rent, you can list them separately. Usually I lump everything together because there's no confusion. But it can cause confusion to the tenant. So if late fees are $50 and rent is 1,000, my method is you owe me $1,050. But you could also say you owe me $1,000 for rent and $50 late fees for a total of $1,050. But you cannot ask for the 50 unless it's deemed additional rent. Okay?
Okay. Okay. And then another question that popped up, do you have to accept rent for an expired lease or lease that you don't want to renew?
No. So when a lease expires, if there's no notice period in the lease where it says landlord must give 30 days before, and if the landlord's not going to renew, if that doesn't exist in the lease, then it naturally expires and the tenant is expected to move at the expiration of the lease. You don't have to remind them. Of course, it makes sense to remind them, say
Hmm.
where you say, hey, your lease expires at the end of February or the end of March, and I'm not renewing. So, please vacate and return the keys. So you can let them know so there's no misunderstanding, but you don't have to renew a lease at all. You
And
can.
is there some requirement? So if the lease goes from, a typical term to month by month, for example, is there some
Mhm.
required amount of time to let them know that, they would have to vacate?
There isn't any unless you put it in your lease. There isn't any by law, by statute. So we have the statute and we have your lease. And the lease will control in most circumstances. But if your lease is silent and the statute is silent, then you don't have to give any notice. There's no time period where you have to notify a tenant. I'm just saying it's common sense. It makes sense to let the tenant know you're not renewing. But
Okay.
check your
Okay.
lease first.
And I had
Okay.
another question pop up, and I
Yeah.
think probably for the person asking this question, we may need some further clarification, but I'm going to ask it anyway. If
Yeah.
your lease doesn't have a termination clause for the landlord, and then the landlord hires a management company that wants to evict with 60 days notice, can this happen, or do the tenants stay until the end of the lease?
So the best way I can answer this, the hiring a management company really doesn't matter. That's an agent of the landlord, it's the arm of the landlord. This agent cannot come in and change anything in the contract at all. The contract still stands. So if we're going to assume that the contract has no termination clause or the contract was already set, then it doesn't make any difference. A property manager cannot do anything that's not already in the contract. So
Okay.
if that property management company has a policy when they do their leases that there's a 30-day termination or whatever it is, that's not enforceable in that lease that they're now inheriting because that lease is the legal binding contract. Hopefully that helped answer the
Yes.
question. All
Yep.
right,
I think
great.
that was a good clarification. Thank you.
No problem. Okay. Moving along to I think I lost. Okay, there we go. So that's it for non-payment of rent, the most common. Then you have terminating month-to-month tenancies. So a month-to-month tenancy is usually created either from inception, where there's no written lease, it's done on a handshake, and people do it all the time. You'd be surprised. There are a lot of month-to-month tenancies. Had never been a written lease. And then you have those where the lease expired. Some landlords like to do that. The tenant's kind of iffy, always pays late, but they end up paying, so the landlord doesn't want to lock themselves in for another year, or for whatever reason the landlord will just allow the tenancy to go month to month. Month to month tenancies are terminable by serving a 15-day notice. I have some exceptions here, which is City of Miami or Miami Beach, where a 30-day notice is required. But this is called an at-will tenancy. It exists in, I think it would exist in every jurisdiction where there's no written lease to control. So you need to check if you're in a different jurisdiction outside of Florida, you need to check to see how to terminate month to month, or you might see the term at will tenancies. Basically, these are tenancies with no written contract. All right. The only solid defense to this is to make sure that the termination is not retaliatory. Okay, because the tenant can then say, you know what, I called code because my window wouldn't open and now the landlord is kicking me out. That's retaliatory, and you can end up in court for that. So terminating month-to-month tenancies here, there's never been a lease. Rent is due on August 1st. Tenant pays rent but is chronically late, does not get along with other residents. When can the landlord serve the notice and when does it expire? So here's the rule, simple rule. If rent is due on the 1st, just remember that your 15-day notices always need to expire the day before rent is due. That's rule number one. Your 15-day notices or 30-day notices, depending on Miami Beach, is that the notice needs to expire the day before rent is due. Then you count backwards in time to make sure that you have 15 days left before the rent is due. That's a simple way to terminate month-to-month tenancies. A lot of people terminate month-to-month tenancies. They give their 50 days anytime they want. So today is what, the 28th? And they will say, no, the 27th. And they'll just say, you know what, I hate this tenant. I'm going to give them a 15-day notice. And they serve it today. And then it's going to expire maybe March 13th. That is an unenforceable 3-day notice and it's 15-day notice, and it's defective at that point. You are terminating in midterm. So that is a defective notice. So if you wanted someone out of your property by March 1st, it's too late in February. There aren't 15 days left in the month of February, so it's already too late. So here's how you would calculate. I'm giving you one example here. If rent is due, so rent is due on the 1st of every month. In this example, August 2019, August 16th would be the last day you could serve a notice, and day one would be the 17th, and then that notice would expire on the 31st because rent is due on the 1st. All right? So that's the rule. Just remember that. Make your notice expire the day before rent is due, count backwards in time, and if you have 15 days left, great. You can serve that notice and it's good. Otherwise, it has to terminate the following month. Okay. Lease expired a month ago. The parties never renewed, but landlord accepted rent. Under the lease, rent was due on the 15th day of every month. When can the landlord serve the notice and when does it expire? I use this example to show you that because rent is not always due on the 1st. And if you follow my rule, then it doesn't matter when rent is due. It could be the 7th. It could be the 6th. It doesn't matter because now you know how to calculate it. So here we have the 15th is when rent is due. Your notice just needs to expire the day before rent is due, and then you count backwards to present time. And if you have 15 days, you're good. Your notice is going to be good. All right. Here's another way to terminate tenancies, and this is for breach of lease. And this is extremely hard to do because the burden is on the landlord to prove this. So when a tenant breaches the lease, you have to serve a 7-day notice to cure. The law assumes that most breaches are curable. Unwanted guests, unauthorized pets, curable, which means if the tenant has a dog, you're supposed to serve a 7-day notice telling the tenant to remove the dog. And if the tenant doesn't remove the dog, then you're authorized to file an eviction. If the tenant removes the dog and then they get another form of unauthorized pet, then you can still move forward with an eviction because they are violating the pet clause. Breaches are usually non-curable if it's criminal activities, so 99% of leases are going to be it's going to be curable. And here's a simple format. I'm not going to go through everything here, but in this format, I've listed 3 different types of violations. One is the air conditioning filter. I listed that because it's not really material. A judge would never grant you an eviction for the tenant not changing their AC filter. The second one, withholding consent for the landlord to access the premises by changing the locks. That one you can enforce. You give the tenant 7 days to change the locks back and to give you a copy. And if the tenant doesn't do that, then you can move forward with an eviction. The third one, unauthorized alterations. In my example, I used changing the locks, but it could be an above ground pool, a tiki hut, whatever. You need to give them a chance to cure it. And if they don't cure it, you can move forward with an eviction.
I had another,
Yes,
if I could
sure.
interrupt for just a minute, I actually had a question on the 15-day notice. So weekends and holidays
Yes.
count for the 15-day notice, but not the 3-day notice. Is that
Yes,
correct?
you are correct. Yes. So weekends and holidays, and it can expire on a holiday, it can expire on a Sunday, it doesn't matter, because it has to expire the day before rent is due. So yes, 15-day notices, it's calendar days. 3-day notices, you have to skip weekends and holidays,
Okay.
both holidays.
And okay. And then another question on the 15-day notice. Does the due date for rent include any grace period, i.e., with the example shown where rent was due on the 1st? Were there
No.
5 days grace period or anything like that?
No, because if you're talking about the 15-day notice, this is not about rent. You're just exercising your right to terminate an at-will tenancy. The tenant can do the same. I didn't say that before. So there's no grace period involved in this. You're not asking for money. You're not saying if you pay late, that late charge applies after the 5th. You're just terminating the tenancy. I don't want you in the property anymore. So there's no grace period unless it's written in your lease where you say you change the terms, you change the law where you say instead of 15 days, it's going to be 30 days. If you had a lease before and you say, if this goes to month, then landlord is required to serve a 30-day notice. That is kind of
Okay.
an extra grace period you're giving, but the lease is what would control in that
Okay.
circumstance.
And
Yeah.
actually, based on that, I had another question pop up here. If there is no lease and it's month to month and the tenant is doing criminal activity, and they give examples here, can they be evicted?
Mm. Criminal activity. So there's no lease. Repeat this again. I'm sorry, I missed it.
Right, exactly. There is no lease. They're month to
Yeah.
month and there's criminal activity. Can they be evicted?
Um, the yes. So if it's month to month, but what I would do is just terminate the month to month tenancy. Because now you don't need any reason to terminate month to month tenancies. On the other hand, if you try the 7-day notice to cure, then the burden of proof is on the landlord, and you're going to have to prove that they did criminal activities, and the tenant's going to say, it wasn't me that did it, it was my friend who did it. So you don't have to deal with that. So if you have that choice, and that's a very good question, if it comes down to it that you have a tenant that you don't want, and the tenant has violated the lease and committed some sort of crime, I would just terminate the month to month tenancy because now you need no reason at all. They're going to defend whatever reason you give them for the 7-day notice. They're going to say, no, that wasn't my dog. That wasn't my crime. That was a friend of mine. And the police dropped all the charges. They're going to say all those things. And you have the burden of proving in court. So terminate the
Okay.
month to month tenancy.
Okay, and I'm assuming that if you gave more of a notice than required by law, that's fine, and maybe giving
Yes.
yourself a little bit of safeguard.
That is correct. So if you have a you want your property back, but you had a tenant who's not a bad tenant, you can give them an extra long notice. You can wait until you collect March rent, and then you can give them their notice to vacate for April. You could give them, 29 days. You can always give more, just not less. All right?
Okay. And I just want to remind everybody on the webinar that Conrad is a Florida attorney, and I saw some questions pop up for other states. So I just want to encourage you to reach out to professionals in those areas because Conrad's professional, his area of practice is Florida law. So keep that in mind.
Yes. And the laws are very specific. Even in Georgia, which borders Florida, it's completely different. But this should trigger some questions in your mind. All these, there's going to be, the laws might be different, but you should be able to ask the right questions. If you need an attorney, or even if you're doing a Google search, now know what to search for. All right, I'm going to move forward. So, as I said, 7-day notice to cure, and so on, with an opportunity to cure. You would give 7-day notice to cure for unauthorized pets, unauthorized occupants, unsanitary conditions. These are all real photos from cases that I've been involved in. Here's an example. Tenant is month to month. Lease has never been signed. Landlord discovers the tenant is hoarding garbage. This actually is similar to the question that someone asked about crime and the month to month tenant. Here, I would just tell the client to terminate the month to month tenancy. If you want the tenant gone, terminate the month to month tenancy. Otherwise, you're going to give them a 7-day notice to cure for hoarding garbage. They're going to clean up the issue, and then it's going to come right back. Or you're going to end up going to court, and the tenant's going to say, I don't hoard garbage. You don't have any proof of that. It's the burden of proof is on you, so avoid that if you can. Tenant moves her boyfriend into the property. Boyfriend is a nuisance to the other tenants. He drinks in public, plays loud music, and harasses other tenants. That's bad for business. If you have other tenants, they're going to just start leaving. They're not going to renew. So you need a person like this out of the property. You need to start documenting, and you need to serve the tenant with a 7-day notice to cure for her unauthorized guest. For her, this is all about her. Her guests drinking in public and causing unreasonable disturbances. And you do an entire list of things. And then if this issue comes up again, then you can evict her. You cannot evict the boyfriend. You have no privity of contract with him. Landlord is aware that the tenant's girlfriend lives on the premises and has lived there since commencement of the lease. Landlord communicates with the girlfriend regularly, accepts rent. Landlord then tries to evict the tenant in month 10 of the lease based on unauthorized occupant claim. I threw this in here because it's a waiver. If you treat someone like a tenant, and you've dealt with the girlfriend, and you even collect rent from that person, and then because you have a falling out, you try to evict that person, it's not going to work with the judge. It's also best to not be on friendly terms with your tenants, because this is the kind of example of what happens. Tenant punched another tenant, threatened to kill him with a knife. There's a police report. With something like this, you can give a notice of termination, a 7-day notice. There's nothing to cure here. I can't imagine what you would say in a notice to cure for this. Yeah, so that's when you use a 7-day notice to cure. Here's the process in Florida. You have, depending on the county, it's estimated 4 weeks. So if you are a landlord, you're an investor, you have property, it makes sense that you run a tight ship, because during your eviction, most people do not pay. They say, oh, you're kicking me out, I'm not paying you any rent. And you also need to be prepared for this. Whichever jurisdiction you're in, you have a mortgage to pay, or you have the taxes to pay. You have to always imagine that there will be tenants who do not pay. And so what do you need to do? You need to have a plan. You need to either have your lawyer standing by, or if it's a state that does not require an attorney, you need to know what to do. You need to know what notices to serve, and you need to know how long the process is going to take. So depending on the county, if it's Miami-Dade County, which is the largest county and the most populous county, I should say, in Florida, that could take you up to 2 months, even though Florida evictions move much more quickly than New York State evictions, for example. And if the tenant files an answer, then you can add 2 weeks to that. However, if you're in Palm Beach County, third largest county, your eviction could wrap up in 4 weeks, but always add the 2 weeks if the tenant gets contested. And you're gonna be spending money, and you're gonna be without rent during that time period. So you deliver your 3-day notice or whatever notice of the 3 notices I just talked to you about. You deliver your notice, wait for the notice to expire, and if the tenant is still in the property, then you need to go to the county court and ask for possession. That's really what you're doing. You're filing a lawsuit asking for possession of the property. A process server is going to serve the tenant. You're going to do a motion for default. You're going to submit a final judgment to the judge if the tenant does not answer within 5 days, and the judge is going to take about 10 days to enter a final judgment. So you're waiting on the judge half the time. Once you get that final judgment, you can then send that on to the sheriff and pay them their $90. The sheriff is going to post a notice after getting paid. Sheriff's going to post a notice and make an appointment with the landlord to go to the property and remove that tenant. It can take up to 14 days. In Miami-Dade, the sheriff takes 14 days. In some other smaller counties, it can be as little as 5 days. You can get your property back. So keep this in mind. When you have property, you have to think about this. This could be a loss, and it happens a lot. I do about 300 evictions per month, and I've been doing this for 10 years, and I've done over 21,000 evictions here in Florida. And so it happens more often than not, whether it's a good economy or bad economy. When the economy was bad, well, I was doing 300 evictions, and the economy is good, I'm doing 300 evictions. So if you have property in Florida, people don't like paying their rent sometimes for whatever reason. Moving on. Quickly, I'm going to wrap this up. As I said, this is a much longer class, but I wanted to give you at least, the basics, the types of notices, and the process. And I'm going to give you some things to keep in mind. Service members, when we file a lawsuit and the person doesn't answer, we can ask the court for a default, which means you didn't answer, so you lose. If we do a military search, which we do for everyone who doesn't file an answer, and we find that the person is in the military, the court will not enter a default because that person could be deployed somewhere. There could be a valid reason why that service member has not paid the rent or why you have not heard from them. So we need to bring that to the judge's attention, and the judge would then bring everyone in and take it from there, make decisions as to should we get an attorney to contact his commander, or should we stay this for 90 days? So that's one thing. That's one way of protecting our service members. Moving forward, I have a sticky mouse here. Larissa, could you move? Okay, thanks. What if the tenant files an answer? So if you're a property manager, so when a tenant files an answer, there are a few things you need to do. It could get more expensive for you, but a judge might order rent into the registry, say, tenant, why don't you pay the $2,000 in the registry? Or the judge could order mediation, a hearing to determine rent, or a final hearing. So there are other steps involved once a tenant files an answer, and the savvy tenant always files an answer because it buys them time. We then, as attorneys, have to move the case along. So now it's extra work. So always keep those things in mind. Next. Oops.
Which slide was it? I'm sorry. Yeah.
Yeah. Just go forward 2 slides for me.
2 slides. There you go.
Forward. This is, yeah. Okay. So stipulation agreements. So a stipulation agreement, this is how you wrap up a lawsuit when your tenant, otherwise good tenant, you start your eviction, the tenant comes to you and the tenant says, you know what, I'm willing to pay, I just don't have all the money. And you want to work with that tenant, you can get into an agreement with the tenant, and then the judge will sign off on it. So here's an example. You start an eviction against the tenant. The eviction is contested by a legal aid attorney. Legal aid says a tenant will leave in 2 weeks and waive return of deposit. Now, legal aid attorneys are free attorneys that the tenant gets. You're paying for your attorney, theirs is free. Their attorney is going to try to buy as much time. You are losing time and money. So the best thing to do is do a stipulation where the tenant's going to move out and you're going to get your deposit back. I mean, not your deposit. You're going to get the property back and the tenant's going to waive return of the deposit. Here's another one. Landlord files eviction against tenant for 2 months of back rent. Tenant files a counterclaim, states that the roof was leaking, and so on. If all this is true and it's the landlord's fault, the landlord should take this deal. And so this is what another example of a stipulation. You're in a bad situation where you could lose. Here's the other one. Tenant and landlord enter into a stipulation for settlement. The tenant agrees to repay money, and the tenant makes some payments but fail to leave at the end of the lease. You don't need a new eviction because the stipulation said they should pay. So you just need to let the judge know. Whether it's 6 months later and this tenant failed to leave, you just need to let the judge know. Judge, we had this agreement. We all signed it, Your Honor. You signed it also. And the tenant is still in the property. The tenant didn't leave. You don't even have to go back to court, and the judge will enter a final judgment. Finally, writs of possession. This is the very end stage of an eviction, and this is when you should get a writ of possession. Everyone should get a writ of possession unless the tenant gave you the keys and put something in writing that they are leaving the property. So that is all the time I have. As I said, this is usually at 90 minutes, but I think I've covered all the basics that you need. We can make this available, and I will be available to any of Larissa's clients or audience members who are on this webinar. They can reach out to me, ask questions. She can give you my contact information
Yeah,
and
and
my website.
is it
Go
on the
ahead.
last slide there, Conrad?
I'm sorry.
Is
No, because I did have some more. There was like a part 2 that goes on. So yeah,
okay.
right here at the very
Here,
end.
we'll give
Yeah,
we'll give you there we go.
yeah.
So there's his contact information there. You are certainly welcome to email me, and I will make sure to get you in touch with Conrad as well. I know we kind of ran out of time for questions, and there were still a few posted, so please feel free to email me or get in touch with Conrad. And Conrad, if there's a second part to this webinar, we definitely would love to have you back and finish up and get more questions answered. And I really
Absolutely.
appreciate you joining us.
I have there's fair housing and there's a part 2 to this. So you and I can talk, and if
Okay.
people want to do that, I'll be happy to do that for you.
Okay, thank you so much, Conrad, and
Okay.
thank you so much, everybody, for joining us, and we hope you join us again soon.
All right. Appreciate it. Thank you. Bye.
Thank you. Bye-bye.